1 minute ago, a new set of records landed in the court file and immediately changed the shape of the case, collapsing what had previously been presented as a stable timeline involving Ivanka Trump and triggering a rapid, aggressive response from Donald Trump's camp. What matters here is not just that new records surfaced, but that they appear to realign sequence, timing, and access in a way that forces the court to reassess how earlier explanations fit together. When timelines collapse, cases stop being about interpretation and start being about order of events. According to the filing activity, the records were submitted as part of a supplemental evidentiary update rather than a standalone accusation. That distinction is important because supplemental records are typically used to tighten an existing narrative, not invent a new one. These materials reportedly include authenticated data points tied to communications routing, calendar activity, and transaction timing. Individually, none of these elements would necessarily be decisive. Together, they are being used to argue that the sequence of events cannot be reconciled with how the defense previously framed Ivanka's role. Courts pay close attention to sequence because sequence is how intent is inferred. When a timeline holds, parties can argue coincidence, delegation, or administrative distance. When a timeline collapses, those arguments become harder to sustain. The judge's focus shifts from managing pace to managing credibility. That shift appears to be underway now, which explains why the court moved quickly to absorb the new records rather than pushing them into a later briefing cycle. The moment the filing became visible, Donald Trump's team went on offense. A public response followed almost immediately, attacking the timing, the motives, and the framing of the new records. From a political standpoint, this kind of response is familiar. It signals control, confidence, and resistance. From a legal standpoint, it signals something else, recognition that the procedural ground may be shifting beneath the case. What makes this development especially sensitive is that the records do not appear to rely on interpretation-heavy testimony. They rely on metadata, timestamps, and system-generated logs. Courts treat this category of evidence differently because it is less vulnerable to memory, bias, or spin. You can argue about what a message meant, but it is much harder to argue about when an account was accessed, from where, and in what order actions occurred once those records are properly authenticated. As the new records entered the docket, the court's posture subtly changed. Rather than focusing on abstract disputes, attention narrowed to preservation, scope, and process. Judges do this when they want to lock the factual landscape before arguments expand. It is a defensive move by the court, designed to prevent future claims that evidence was altered, lost, or misunderstood. That defensive posture often precedes faster decisions, not slower ones. For Ivanka Trump, the pressure point here is not public opinion, but alignment. When timelines collapse, every explanation must fit the same sequence. Legal teams, advisors, and anyone with knowledge of the relevant events must now ensure that their accounts do not drift. Even small inconsistencies become magnified once a court begins testing chronology rather than intent. That is why timeline disputes are often more destabilizing than substantive allegations. Trump's decision to go on offense at this exact moment highlights the growing gap between public strategy and courtroom mechanics. Public messaging can dominate headlines, but it does not change timestamps. Judges are not persuaded by tone, they are persuaded by order. When statements are made publicly during moments of procedural tightening, they can later become points of comparison against sworn filings. That is a risk calculated teams sometimes take when they believe momentum matters more than restraint. Behind the scenes, the collapse of a timeline also widens the circle of concern. If records show coordination or awareness across multiple points, responsibility no longer sits neatly with one person. Preservation obligations expand, certifications become more complex. The more complex those obligations become, the harder it is for teams to move quickly without error. Courts know this, which is why they often act early once sequence-based disputes surface. It is important to note that a collapsed timeline does not equal a final conclusion. Courts distinguish between procedural risk and substantive guilt. What today's development signals is not an outcome, but a change in how carefully the process will now be managed. Judges move fast not to punish but to prevent confusion. Once confusion enters the record, it is difficult to unwind. As of now, the new records are in, the timeline they support is being scrutinized, and the court has clear reason to keep the process tight. Trump has gone on offense publicly, framing the moment as escalation. The judge, meanwhile, appears focused on control, sequence, and preservation. Those priorities rarely align, and when they diverge, the legal process tends to assert itself. The next phase will be defined by filings rather than statements. If the record supports a coherent revised timeline, the court may press forward quickly. If disputes over scope or interpretation multiply, the court may narrow even further before expanding. Either way, the collapse of a timeline is not a minor procedural event. It is a signal that the case has entered a more rigid, less forgiving stage. Right now, the noise is loud, but the real story is quiet and technical. New records have changed the order of events. That change has consequences. And once a court starts measuring a case by sequence rather than spin, the room for maneuvering shrinks fast.